This conference will now be recorded.
Hello everyone, my name is Arushi Grover. I'm working as an assistant professor in Institute of Information Technology and Management, Janakpuri. Students, today I'm going to discuss a topic from Unit 2 of Entrepreneurship Development. The topic is legal requirements of establishment of a new unit. We will cover aspects like stages in formation of a company and documentation required at various steps. Let's start with the introduction of this topic firstly. So whenever any entrepreneur decides to start a new business venture, one should keep in mind to make sure that they are complying with all the legal obligations of running a small business. They need to make sure that the company complies with all its legal responsibilities so as to avoid any further legal consequences. Establishing a new business unit is a complex and risky task. Entrepreneurs have to comply with various legal formalities to establish a new unit. These formalities differ in relation to the form of enterprise adopted by the enterprise. So, the form of ownership, form of enterprise could be sole proprietorship, partnership firm, or any other company. So, the legal formalities will differ. Legal formalities may be necessary at different stages of the startup also. So the legal requirements also differ in reference to the size of the business unit, such as small scale, medium scale, or large scale enterprises. So all these legal regulations and obligations need to be abide by. Stages in formation of a company includes first step as promotion stage. Now in promotion stage, promotion basically refers to the sum total of the activities of all those who participate in building of the enterprise and completion of the plan to exploit the idea. So basically, in promotion of a company, the idea is to convert the potential idea into the opportunity. How can it be done? It follows certain steps. It begins with the serious consideration given to the ideas on which the business is to be based. Promotion may be defined as the discovery of business opportunities and the subsequent organization of funds, property, and managerial ability into a business concern for the purpose of making profit. A person who basically undertakes all the activities that are involved in converting an idea into an opportunity and hence establishing an enterprise, this person is called as a promoter. Now, as a promoter, the job is to originate a scheme for the promotion. This person gets the memorandum prepared, articles prepared and registered, and funds the first directors, settles the terms of preliminary contracts and prospectus, and also makes arrangement for raising the capital. In the next stage, that is the second stage of this process, that is incorporation. Incorporation or registration stage that it is commonly known as. It includes that company is established through legal procedure and have a separate legal entity from its owners. To gain this, legal entity, legal procedure of establishment, a company is termed as incorporation. For this particular purpose, registration of company has to be made with the registrar of companies. An entrepreneur is required to submit an application for registration. These documents would include application that has to be duly filled in and signed by an authorized person. The second one, most important, is memorandum of association. Now, this memorandum of association is considered to be a charter of the company. It's a fundamental document, a very important document that defines, that includes the objectives of the company, its name, the address of its registered office, the capital which the company is authorized to raise, the nature of liability of its members, as well as the names, address, and agreement of people who agree to form a company. So all the relevant information and details are mentioned in the MOA of the company. Next is Articles of Association, another document that is used in this particular stage. That is Articles of Association. It is a document which contains the rules and regulations pertaining to the internal management of the company. All the rules, regulations, policies, and procedures which are followed or which will be followed by the company are written down in this Articles of Association. It is also not necessary for a public company limited by shares to file the Articles of Association. If such public company does not file the AOA, they can adopt the Table A of Schedule 1 of the Act, Companies Act, wherein they would find the Articles of Association which they can imbibe in their organization. Next is written consent of the directors. So it is very important to take the consent of the directors in written who agree to act in that capacity. The consent has to be signed by each of the directors along with a written undertaking by them to take the necessary qualification shares, if any, as provided in the articles. Next document is a copy of agreement with any individual for appointment as a managing director or a whole-time director or manager. So this would be another agreement. Then a statutory declaration has to be filed, which would state that all the legal requirements of the Act, of the Companies Act, precedent to incorporation have been complied with. That means all the documents that were required to be filed at this particular stage has been complied with and the organization has taken care of. Next is address of the registered office of the company. However, a company may file registered address within 30 days of its registration. Next is at the time of registration, the prescribed registration fees and filing fee for each document filed for registration are to be paid to the registrar's office. After receiving all these documents, the registrar of companies would scrutinize, would determine, would analyze these documents, and if he or she is satisfied that all the documents are in order, he shall enter the name of the company in the registrar of companies and issue a certificate of incorporation, which is also known to be as a trading certificate. Certificate of incorporation is required to pursue or to trade or to start your business activities. For a private company, they can start their operations after getting the certificate of incorporation, but for a public company who will be raising funds from the public, they need to firstly go through all the processes and get the certificate of commencement, and then only they can start their activities, business activities. So moving on to the third stage, which is mandatory for a public company, that is capital subscription stage. Next step in the registration of a company is to raise capital for the proposed company. When a company decides to raise capital from public, they invite public to invest in their shares. The following procedure is adopted for this purpose. That is, permission is taken for public issue from the Securities and Exchange Board of India. Agreements with underwriters, brokers, and agreements with the underwriters, brokers, and share issue managers. Filing a copy of prospectus with the registrar. Invite the public to purchase the shares of the company by putting the prospectus in circulation. Receiving applications for shares through the company banker. Formal resolution of allotment if the subscribed capital is at least equal to minimum subscription of 90% of capital issue. In case minimum subscription is not received, the entire amount with application would have to be refunded at the end of 120 days from the circulation of prospectus. Issue of allotment shares has to be done and share certificate should be given to the investors. In case a company having a shared capital but not issuing a prospectus needs to file a statement in lieu of prospectus with the registrar at least 3 days before the first allotment resolution. Next step, that is the fourth step in the formation of a company, is commencement. Commencement of a business. A public company cannot commence its business immediately after the incorporation stage, that means after getting the certificate of incorporation, unless it has obtained a certificate of commencement of business from the registrar of companies. For getting that certificate of commencement, following documents have to be filed for this purpose. These are shares payable in cash have been allotted to the extent of the minimum subscription. That means this document needs to be submitted stating that all the shares that were payable in cash have been allotted to the extent of the minimum subscription. that is 90% of the capital issue, and another document which would state that every director has paid in cash the application and allotment money on the shares taken by him. Third declaration would be no money is liable to be refundable to the applicant for failure of the company to apply or obtain permission for the shares or debentures to be dealt in on any recognized stock exchange. Another statutory declaration is duly verified by one of the directors or the secretary in the prescribed form that all the above conditions have been complied with and has been filed with the registrar of the registrar will scrutinize these documents. If the registrar is satisfied, he shall issue a certificate of commencement of business. This certificate is known to be every company also can start its operation, its business activities, and can commence its business and use its borrowing powers. Thank you. I hope this will clear the relevant details about the legal requirements, and this would help you to learn more about it. Thank you.